esteemed lawyers and colleagues, Mr. Ricky Harnanan, as well as Mr. Kingsley Walesby, and of course, our own Varun Gopal Gosain. So gentlemen, please accept our very warm welcome this morning to the Krishna Mandir. I also want to extend welcome to members of the media who are here, members from TV Jagriti and Radio Jagriti, as well as other media houses, and to all of the residents, business persons and others, and members of the Mandir and the various organizations who are here with us this morning, as well as the many hundreds who are viewing us online on YouTube and on Facebook on our live stream. This morning is a very important occasion for us all, and as we begin, I welcome the councillor for the area, Ms. Viliana Ramutar Singh, as she makes her way in, and other members. It is a very important day for us all, where we come to be apprised of the goings-on in the legal arena by our very esteemed senior counsel, Mr. Ramesh Lawrence Maharaj, and members of the legal team. We cannot express in words our gratitude, Senior, for all of the efforts by you and members of the legal team. And I can say this from the very little training that I have in the arena myself, that your work and your dedication has been nothing short of tremendous. And I invite you please to give them a round of applause. From the get-go, from day one, these members, without being asked, step forward and offer themselves in service to our community and in service to our stakeholders, and for that we are extremely grateful. As you know, the legal process, and I won't get into that, is one that is sometimes meandering. There are ups and downs, there are certain pitfalls and unexpected turns and twists. But these gentlemen, by their virtue of their experience and their legal prowess, are well equipped and are always there to guide us and to assist us in navigating sometimes those treacherous waters. We have hit a slight bump in the road, and I am confident, as is the legal team, that it is only a slight bump. And as we always say, stumbling blocks are to be used as stepping stones for something that is even greater, something that is even grander. And so, without further ado, ladies and gentlemen, please welcome to the podium our esteemed senior counsel, Mr. Ramesh Lawrence Maharaj, who will address us this morning.
Sitaram, namaste. I must first thank you for the opportunity of trying to explain to the members and to the public the issues which are involved in the legal battle which has been embarked upon in order to ensure that opposite of this temple there are no housing units of HDC built, which would affect not only the work of the temple, but would affect neighboring areas. And I want to try to explain to you so that you will understand that this battle, if I may call it that, which has been embarked upon, is not only a battle for you, it is a battle for Trinidad and Tobago, because after this matter is finally determined, there will be a precedent that in respect of the change of use of land, that there has to be a procedure and rights and legitimate expectations which have accrued to individuals and groups have to be respected. So I would like to thank my legal team. I have Mr. Bisessa, the first gentleman. Can I ask you to stand? Mr. Bisessa is the senior counsel. Next, I'll ask Mr. Ricky Harnanan to stand, please. Mr. Kingsley Walesby. Mr. Varun Gopal Gosain. And there's another lawyer, Mr. Michael Ruplal, who is not here today. He's in the United Kingdom. I would also like to pay special tribute to Pandit Rudranath Maharaj, an attorney at law also, for his leadership and his cooperation and his mobilization, and the other claimants in the matter for all their cooperation which they have given in making our task simpler. Krishna Mandir, Sri Krishna Siva Trust Foundation, Sri Sivak Sabha Incorporated and the concerned citizens for a better San Fernando have filed a claim against the Cabinet of Trinidad and Tobago and the State of Trinidad and Tobago, represented by the Attorney General. That claim is a claim in which it challenged the lawfulness of the decision made by the Cabinet on the 8th of September 2022, by which the Cabinet agreed to transfer to the Housing Development Corporation 1 hectare of land situated at Todd Street, which is opposite this Mandir, for the purpose of constructing multifamily apartments units consisting of 72 of such units. And it will be in 3 towers. I should let you know that that decision was made by the Cabinet without the Cabinet or anyone consulting either the Mandir, the Krishna Mandir, or any of the claimants or any of the groups in the area. That is very important because I would show you that in law, Krishna Mandir and the other claimants, by the use, the designated use of that land opposite the temple, that land was designated over 70 years ago by the Town and Country Planning Division to be used for the building of a technical and primary school. In 1951, there's a survey plan at the records of the Town and Country Planning Division, which has been exhibited and which has been part of the evidence put in by the Cabinet of Trinidad and Tobago in the case which was before the judge, that since 1951, this land has been designated for planning purposes to be used solely for a building of a technical and primary school in what is called here a school zone. Before Cabinet made that decision, in September 2022, we had a situation in which the Cabinet knew that the land was designated for the building of a technical and primary school, and Cabinet also knew that attempts were made by the HDC to try and get the TCPD, which is the Town and Country Planning Division, to change that use. So you remember I told you Cabinet made that decision on the 8th of September 2022? Well, the first time your pundit knew and your group knew that such a decision was made, I think was in about November of 2022. So that is the first time it was known to your group that the Cabinet had made a decision to change the use of the land. But before you knew about it, what happened was the HDC made an application in March 2022. They drew a plan and they drew a layout to build these housing units. And it sent that plan to the Ministry of Education and the TCPD in order to get their consent and no objection from them to build those housing units. And all that time you did not know what was happening. But it's a matter of record that the Minister of Education on the 8th of March 2022 wrote to the Town and Country Planning Division, wrote to the HDC and indicated to the HDC that the minister did not have any objection for that land to be used for the building of housing units. And you did not know about that then at all. But what happened, the permanent secretary in the Ministry of Education wrote to the HDC on the 29th of July in response of 2022, in response to requests made by the HEC for the Ministry of Education not to object to the use of the land for the building of housing units, responded to that letter, and it took a different position than what the minister took. The permanent secretary in the Ministry of Education took the position that that land is designated for the building of a technical and primary school, and the Ministry of Education would not consent, and as a matter of fact would be objecting for the use of that land to be changed to build housing units. So I am telling you this for you to see that the cabinet in September, when it made its decision to change the use, knew what the Ministry of Education was saying. The HCC also wrote to the Town and Country Planning Division to try and get the Town and Country Planning Division to agree for the change of use of the land. So the Town and Country Planning Division on the 7th of April 2022 wrote back to the HEC and told the HEC that they did a site visit and that that land had an existing policy for its use, and that land could only be used for the building of a technical and primary school. The Town and Country Planning went further and to say that there are schools in the area and the land is suitable as a school zone. Based on that letter from the TCPD, which is the Town and Country Planning Division, the HCC then decided that the Ministry of Education is against it, the TCPD is against it, so then they decided that they will try the cabinet. And the cabinet decided, and I must congratulate the organizers for getting a copy of the cabinet minute. This is the cabinet minute, and I'll read to you what the cabinet decided. The cabinet decided on the 8th of September 2022 that it agreed to transfer the parcel of land comprising approximately 1 hectare situated at Todd Street, San Fernando, to the Trinidad and Tobago Housing Development Corporation to facilitate the development of multi-housing with an estimated yield of 72 apartment units pursuant to Section 13 of the Trinidad and Tobago Housing Development Corporation. So in effect, what the cabinet decided, that forget what everybody else is saying. We, the cabinet of Trinidad and Tobago, have decided that we transferring this land to the HEC for the HEC to build housing. But in this said cabinet minute, let me read to you what cabinet noted. Cabinet noted that, and I quote, "The above-mentioned parcel of land forms part of a larger parcel of land comprising approximately 10 hectares, which is assigned to the Commissioner of State Lands for the construction of a technical and primary school." And then they give a description of the land. So when Cabinet made this decision on the 8th of September 2022, Cabinet knew that the land was assigned to the Commissioner of State Lands, not for the building of housing units, but for the building of a technical and primary school. Cabinet also knew that the TCPD had done a site visit and had told the HDC, the Town and Country Planning Division had told the HEC that this land has been designated for the building of a technical and primary school, and it has been designated since 1951, 70 years ago, exactly 71 years ago. Cabinet also knew that the HDC tried to get the Ministry of Education. The Cabinet was able to get the Minister of Education, but the Minister of Education is different to the Ministry of Education. This may sound strange to you, but in this kind of matter, the minister doesn't have a say. It's the ministry that has the say. Because the ministry consists of all the technical people. And the Ministry of Education said that we are not consenting for the use of this land to be used for any other purpose than for the purpose of a technical and primary school. And very important, when we filed a claim against the Cabinet and the state, what happened? They put in evidence. And one of the pieces of evidence they have put in is an affidavit from a man called Kerry Pariak, who is one of the town planner of the Town and Country Planning Division. And what did he say in his evidence? I'll tell you what he said in his evidence. He said that based on the official records of the Town and Country Planning Division, there's a survey plan of 1951 dated the 13th of April 1951, which shows that as at that date and continuing, the subject land was allocated for a technical and primary school. And the TCPD since then, when I say TCPD, I mean Town and Country Planning Division, since then has been treating the 10 hectares of land as designated for the building of a technical and primary school, which is known as institutional use. So let me explain something to you, and I want you to try and understand it. In 2000, there was an act called the Judicial Review Act, which was passed as law in Trinidad and Tobago. That act was passed when I was the Attorney General of Trinidad and Tobago. I got the government to agree to put that act in the Parliament, and that act is the law of Trinidad and Tobago. Before that act, it had an unwritten law, and it's called common law rules, in which it gave the right of individuals and groups to challenge decisions made by public authorities, and the court had the jurisdiction to strike down any decision that is unlawful. When that act was passed, what we did, we codified into law what was the common law so that no government could change that unless it goes to Parliament and you'll have to get a special majority and etc. So that Judicial Review Act is the law of Trinidad and Tobago. No one in Trinidad and Tobago is above the law, not even the Cabinet. So the Cabinet, although it has powers under Section 75 of the Constitution of Trinidad and Tobago, now the Cabinet of Trinidad and Tobago is the core government members. The Prime Minister picks certain members of his team, and they form the Cabinet as like the executive. So the Cabinet is given the power under Section 75 of the Constitution of Trinidad and Tobago to make policy for Trinidad and Tobago. But that power in Section 75 of the Constitution is subject to the laws of Trinidad and Tobago. Under the laws of Trinidad and Tobago, the Town and Country Planning Division determines what use is to be put to land. If you have to change the use of land, you have to make an application to the Town and Country Planning Division, and the Town and Country Planning Division would do an examination, site visit, and then they would decide what use of the land, because they will consider whether if you build housing there, whether it would affect the work of the temple, the activities of the temple, the activities of the school. It will cause more traffic congestion. It will cause a lot of noise if they have to build there'll be vibration. It could cause drainage problem. You could have a situation where you have a nightmare situation, if I call that, in the area. Because right now, according to the evidence, you already have a nightmare situation. So the town and country planning will have to consider all of that. And the town and country planning also will have to consider, well, if this is a school zone, it has about 7 schools in this area, I understand. And on this 1 hectare of land, you have 2 secondary schools. So the town and country planning considered all of that already and said they are not going to approve this for the use of building housing units. So the cabinet, although it made a decision on the 8th of September 2022 for this land to be transferred to the HDC, we have no problem. You could transfer the land to the HDC, but what you cannot do is to build housing units on the land. And we are saying in our case to the court that we recognize that the cabinet has the power under Section 75 to make policy, but cabinet is not above the law, and cabinet is subject to the law of the land. And what we also say is that the courts of Trinidad and Tobago have already decided in principle what our case is. And let me try and explain that to you. You remember some years ago in Trinidad and Tobago, there were some maxi taxis who stated that the government had promised them and that they would get Citygate as the hub for the maxi taxis, and that they would get that. And then I think one of the ministers changed that and changed his mind. And we went to court. We went to court on behalf of the maxi taxis. And the matter reached the Privy Council. And the Privy Council decided that although it doesn't have any paper, it doesn't have any deed that they will use it as a hub for the maxi taxis, that the maxi taxi drivers and owners acquired a legitimate expectation of a substantive benefit that the government would give that maxi taxi drivers the use of Citygate. And the matter went to the High Court, it went to the Court of Appeal, and we went to the Privy Council. The name of the case is Papanet against the Attorney General of Trinidad and Tobago. And the Privy Council ruled not only in favor of the maxi taxi, that they entitled to it, and the government had to give it to them, but ruled that the maxi taxis will get compensation for the wrong that was done by the government. I want to tell you about another case that falls squarely within your case. Mr. Bisessa and I, we were in that case, a case of Pan Trinbago versus the Attorney General, I think. Yeah, the Attorney General and the National Carnival Commission. What happened? There was a settled practice like your case. Your case is there's a settled policy and practice for that land not to be used for any other purpose than for technical and primary school. That settled policy and practice, which operates for 71 years, have given not only you and the groups that have filed the case, but have given everyone in this area a legitimate expectation of a substantive benefit that cannot be changed unless certain procedures are followed. So let me go back to Pan Trinbago. Pan Trinbago, over the years, had a settled practice and policy that when you had Panorama in Trinidad, the gate receipts of Panorama will go to Pan Trinbago. So the National Carnival Commission had to give to Pan Trinbago, for it to run Pan Trinbago, the gate receipts. So you might think, well, that is a simple case and it's going to court. Well, that case went to court. And the judge Justice Kukaram, referred to all the existing principles, and he decided that Trinbago had a legitimate expectation of a substantive benefit to get the receipts of Panorama, and the NCC could not change that without following the rules of fairness and etc. So based on that principle of law, that is a rock on which we have put the case for the temple and the other claimants. Our case is that for 70 years, for at least 71 years, there's a settled policy and use for that land to be used as a school zone for building only school, technical and primary school. We are saying that that settled practice created in favor of you and other persons in the area a legitimate expectation of a substantive benefit for the land to be used for that purpose. Your right has accrued in what is called public law. Public law is what the Judicial Review Act was passed about. So your right was accrued in public law, just as the right in Papanet and just as the right in Trinbago. So you have a legitimate expectation, and the court has to honor that. Now, what the law says is that if it is that you have a legitimate expectation of a substantive benefit, the cabinet cannot make a decision to change the use of this land or to purportedly change the use of this land without having consultation with you. In other words, the law is that the cabinet, through a committee or through somebody, was organized before it made that decision. It should have consultation to give you an opportunity to put forward your case why it should not be used. And then you could have cited what the TCPD say, what the Ministry of Education say, and then the cabinet had to consider that and genuinely consider that. And it had to make a reasonable decision, because if it didn't make a reasonable decision, you could have still gone to court and challenged it. But since the cabinet did not consult you and they breached a legitimate expectation of a substantive benefit, the cabinet decision is unlawful in public law. So what we challenge then, we have challenged the decision of the cabinet to say that the cabinet has made an unlawful decision because it has breached your legitimate expectation of a substantive benefit, and in any event, if they had to change the user, they had to have a hearing with you, consider it, and even give you reasons for their decision. If they had done that, we could have still challenged their decision. So on that basis, I am totally confident. I have been in this law for over 50 years. I know when you have a good case and when you have a bad case. I know when you have a case that is new law and you do not know how the judge will decide. We have a case in which the principles of law have already been decided. But what we have sometimes, we have judges who take different views. Now, the judge has done a part in this case. We as lawyers would do our part. So we went to the court and we cited all of this to the judge, all of this to the judge. And the judge made errors of law. And we have drafted the grounds of appeal, and it's going to be filed on Monday. And what we have put, I'll just read one or two of the grounds for you. We have put as one of the grounds of appeal that the learned judge erred in law in failing to hold that by virtue of the settled policy and practice regarding the use of the said land for a period of approximately 70 years, being for institutional purposes, that this entitled the appellants, who are you, to a legitimate expectation of a substantive benefit, that the said use would not be changed without proper consultation with the appellants as persons who would be affected by the impugned decision. And let me tell you another reason why the decision of the cabinet is unlawful. In the Judicial Review Act that we passed in 2000, in Section 20 of that Act, and those of you who could go do the research, it have a section. It says words to the effect that if a public authority is making a decision which affects the rights or interests of individuals, that public authority has a duty to treat the affected person fairly, which means that it have to give it procedural fairness and to have the rules of natural justice and procedural fairness followed. So we also put in the ground of appeal that the learned judge erred in law and in fact and misconstrued the impugned decision in failing to hold that by the impugned decision, the cabinet in the exercise of its ownership powers over the subject lands changed the designated use of the subject lands from institutional to residential use and changed the policy in respect of the use of the subject lands. The learned judge erred in law in failing to understand or to understand correctly that the cabinet was required, if it intended to change the use of the subject lands, to conduct consultation with the appellants and to practice the rules of procedural fairness. So those are some of the grounds of appeal. Now, I want you to understand this, that as far as I am concerned, the cabinet will never be able to change the use of this subject land. I'll tell you why. We are entitled to challenge the cabinet decision right up to the Privy Council. We will go to the Court of Appeal. I am confident that the Court of Appeal will follow the law. But if for some reason they don't follow the law, just as we went with Paponet, we will go to the Privy Council. And I am committed in this battle for you until it ends. And we intend to fight this battle at every stage. The Judicial Review Act gives you the entitlement. If they do not want to wait until the Town and Country Planning decide this matter, or until the appeal is finished, for us to apply to the Court of Appeal to get a stay of the order of the judge. So that means that the order is put on hold until the Court of Appeal decides the matter. We could also have a second bite at the cherry in challenging the decision, the process at the Town and Country Planning Division. And even if it reaches the AMA stage, we could challenge that too. But the reason we challenged this first stage is that we did not want them to take the point that we delayed. And if you challenge them at this stage and you succeed as you would succeed, you don't have to worry about the other stages. So that is, I'm trying to explain the rationale for us challenging the decision at the cabinet stage. Because there's a law that if you're filing an application for judicial review, you have to act promptly. And there's a limit of 3 months you must file your claim. So if we had waited on Town and Country Planning, and we had filed, they would then say we should file before the file against the cabinet decision, and we out of time. And there are cases in Trinidad where if you file late, you cannot file again. So that is what I'm explaining that, because the judge in a decision seemed not to understand correctly the law, in that she seems to think from a judgment that we should wait until the Town and Country Planning stage, until the EMA stage, and then file it again. But we knew that we couldn't do that because it would have prejudiced our opportunity of challenging it and the cabinet decision was totally wrong. So I think I should tell you also that the claim is also filed against the Attorney General, and the reason we file a claim against the Attorney General also, because if you're filing a claim against the state, it has to be represented, the state has to be represented by the Attorney General. And what we are saying is that the decision of the cabinet did not only violate public law principles, that is to say, what we are saying of it being unlawful and illegal in public law under the Judicial Review Act, that the decision of the cabinet also violated constitutional rights. Under the Constitution of Trinidad and Tobago, everybody, every group is entitled to a right called the protection of the law. It's called a Section 4B right of the Constitution, the protection of the law. And in one of the cases I have done that went to the Privy Council, the case of Samaraj and the case of Allen, it shows that if a public authority has acted very unfairly to an individual or group, that can amount to a violation of the protection of the law. So we have put that in the claim, although we are not filing this claim and fighting this claim for damages, but if this matter goes further and it has to go, let's say it has to go to the Privy Council, you will be entitled also to get declarations, but the group will also be entitled to get compensation for the violation of the fundamental right. And that could be a good gift for the temple, if that happens. Now, I should tell you that in the affidavit of Mr. Rudranath Maharaj, he pointed out some of the problems that we would have in this area if the lands are used for the building of housing units. And he mentioned that under the present circumstances, there is already traffic congestion in the area, and that would be further exacerbated. He said on a daily basis, thousands of vehicles traverse Todd Street in a 2-lane roadway with no room for expansion, and that if you have this situation, it will exacerbate the position. If you have housing units here, it will exacerbate the situation. He stated that there are residents, businesses, and 7 schools in the area, and the use of this roadway by parents, staff, and students have already created a nightmare, and that if you have the construction of these 3-building multifamily complex, it would be disastrous. So he gave reasons, and he talked about drainage and noise and etc. So it is not that there is objection to this project because there are no reasons. If this project occurs, if you have the construction of these units opposite this temple, it will produce adverse consequences, and it is on that basis you are fighting this battle, and we are assisting you to fight this battle. So in closing, I would like to thank you again for the opportunity of explaining this to you, and I want you to understand that you're fighting a battle not only for yourselves, but for Trinidad and Tobago. The cabinet is not above the law. Citizens have a right to go to court to challenge the decisions made by public authorities. In this case, the decision made by the cabinet was inconsistent with the decision made by the Ministry of Education, by the Town and Country Planning Division, and inconsistent with the designated use of the land for a technical and primary school, and which has been in use for over 71 years. In law, the courts have held that a legitimate expectation of a substantive benefit has created for even an enjoyment of a right of a few years. This is a right for 71 years. So thank you very much, Sitaram, and God bless you.
Well, I'm sure, without question, you agree with me that that very thorough and comprehensive overview, done in a few short minutes, I think edifies us all as to the relevance of the issue, the importance of the issue, and the context of the issue that is facing us. And if there was any doubt before, I think those doubts have been clarified without question. So, Senior Counsel, I want to really extend our thanks and gratitude for the time on a Sunday morning when you had the option of doing so many other things, you and the entire legal team, to take time out of your schedule and to be with us to enlighten us on these matters. So before we conclude, I want to make the commitment on behalf of all of us that at the appropriate time in the future, it will be incumbent upon us to express our gratitude and thanks to this legal team in the appropriate manner. This morning, the format of that will be decided, but this morning we are extremely grateful for the efforts. And I can't understate that because I have some inclination about the time, the dedication, and the efforts that are required. You know, very often you see these TV shows about lawyers standing up in front of the court and speaking. What you do not see are the many, many days and nights and hours that go behind the preparation about matters that have to reach before the courts, unfortunately. And I could say without question that this legal team has devoted itself and many, many hours and days and Sundays and other times when you and I might be looking at the football match or the cricket game or whatever, sleeping or having a meal with our family, they are working tirelessly to ensure that your rights, my rights, and our rights are being protected. And that is very important for us to understand and to appreciate and to express our gratitude. I'm sure all of us will agree that Trinidad and Tobago has fallen into a state of lawlessness, and that has affected us in criminality and acts of criminality that are unsurpassed and unprecedented. And when you have lawless actions being taken from the highest echelons of the state, then what is the signal that is being sent straight down the ladder to the man in the street? And we must be vigilant about that. We must be mindful about that, and we must not be fearful about standing up for what is right. And this, my brothers and sisters, is something that is right and it is just. And sometimes it is painted in the media and elsewhere, and I make no apologies for saying it, that it is a Hindu group that is fighting that battle. It is an opposition group that is fighting this battle. And I say to you without question, I am Hindu, yes, but I'm not politically aligned at all. And the fight that is being taken here by the Krishna Mandir of Todd Street, San Fernando, by the Sri Sevak Sabha Incorporated, by the Seva Trust, Sri Krishna Seva Trust, which operates the kindergarten on Holder Street, and most importantly, by the concerned citizens for a better San Fernando. And I want you to understand who this group comprises of. Mr. Ramkilawan, who runs his business right up the road. Mr. Dobson, who lives right up the road. Mr. Mohammed, who lives up the road. The PTA members of San Fernando West and San Fernando Central, of Astra Boys and Astra Girls, of TML, of Astra Primary, the teachers who cannot speak out because they're employees of the Ministry of Education. That are the constituent elements of this group. And so therefore it's not my fight. It is not a Hindu fight. It is the fight for the rights of the well-being of the citizens of Trinidad and Tobago. And we must not lose sight of that. I saw the mother of the minister who is involved in this battle posting on social media that it is the temple people who have a problem. And I want to say to her, it is not the temple people who have a problem with that. It is the citizens of Trinidad and Tobago who have a problem with unlawful decisions. And it is when we stop playing smart with foolishness in this country that we will get back to be the paradise that we are meant to be. Brothers and sisters, on your behalf, I thank our legal team. I thank our esteemed senior. I thank you all and members of the media for taking the time, and I hope we get the coverage that this law warrants in terms of all of the things that's going on in this country, the murders, the dengue outbreak, and everything. This has a place in the importance of our landscape in terms of a national conversation. Sitaram, namaste. Have a very pleasant good day. God bless you all. Sitaram.